Most horror movies have a monster you can see, something with fangs, claws, or a hockey mask. You know it's coming because you can point at it. Now, trade secret theft doesn't work that way. There's no monster in the doorway, there's just an employee finishing their exit interview, a USB drive, and a customer list that quietly leaves the building with them. Nobody breaks a window, nothing gets torched. But 6 months later, you just notice a competitor undercutting you on every deal using pricing that looks suspiciously familiar. That's the horror story of trade secrets, not the jump scare, the slow reveal, 3/4 of the way through the movie, that the threat was something you didn't see coming, and that the thing you should have been protecting the whole time was never protected at all. I'm Julie King, patent and trademark attorney and owner of King Patent Law, and this is Avoid the Legal Horrors, where we talk about the IP mistakes that come back to haunt small businesses. Today, trade secrets, the type of intellectual property almost nobody thinks about until it's already gone. Quick vocabulary check, because trade secrets get treated like the weird cousin of IP law that nobody invites to the reunion. Patents, trademarks, and copyrights, those all involve registering something with the government to get maximum rights. You file paperwork, you get a certificate, there's an official record that says, this is mine. But trade secrets don't work like that. There's no registration, there's no certificate, there's no filing fee. Legally speaking, a trade secret is just information that, number one, has actual economic value because it isn't generally known, and two, is subject to reasonable efforts to keep it secret. That's it. That's the whole doctrine, courtesy of the Defend Trade Secrets Act and the state-level Uniform Trade Secrets Act that most states have adopted. Listen to that second part again, though, because that's where almost everyone gets haunted. Reasonable efforts to keep it secret. The law does not protect things you consider private. It protects things you actually tried to keep secret and can prove you tried. If your idea of protection is, well, I never told anyone, and you also never had anyone sign anything, never locked down who could see the file, never marked it confidential, congratulations, you may have a secret, but you don't have a trade secret, not in the eyes of a court. Here's the part that surprises so many people. Trade secrets aren't just billion-dollar formulas. They're customer lists, pricing models, vendor relationships, manufacturing processes, marketing strategies, the specific way you source materials cheaper than your competitors. If it gives you an edge and you keep it close, it might qualify. Most small business owners are sitting on 2 or 3 trade secrets right now and have never once used that word to describe them. So let's talk about the 2 paths intellectual property like this can take, because this is where it gets fun, at least if you're an IP nerd like me. Path 1, you patent it. You go to the patent office, you show your face, you show your invention, you disclose exactly how the thing works, and in exchange, the government gives you 20 years of exclusivity, 15 if it's a design. It's a deal with very explicit terms. Full disclosure now, protection for a limited time, and then it belongs to everyone. For something you make that's public and can be reverse engineered, this is probably the right path, because keeping secret how it's made isn't worth much if it's easily figured out. Now, path 2, you never tell anyone. You keep it in the dark permanently, and it stays protected for as long as you can keep the secret, which could be forever, like when the twins in The Shining asked Danny to come play with them forever and ever and ever. Coca-Cola made the second choice. The formula has never been patented because patenting it would mean publishing the recipe for the entire world and would have expired decades ago. Instead, it's treated like a cursed relic in a horror movie, supposedly locked in a vault in Atlanta, known in full to only a couple of people at a time, deliberately never written down in one complete place. That's not a marketing flourish. That's a company that understood trade secret law and built an entire mythology around reasonable efforts to maintain secrecy. KFC does something similar. 11 herbs and spices split between 2 different suppliers, so neither one has the whole recipe. Nobody can steal what they can't fully see. WD-40 has never been patented either. The company has said outright that patenting it would have meant disclosing the formula, and they decided permanent secrecy served them better than 20 years of exclusivity. Google's search ranking algorithm, pieces of it are patented, but the actual weighting, the secret sauce that decides what shows up first, that's a trade secret. Guarded the way you'd guard something that, if it got out, an army of SEO consultants would tear apart within a week, which, frankly, they're already trying to do. Here's the horror movie twist, though. This protection only holds as long as the secret survives. Independently discover it? Legal. Reverse engineer it fairly? Legal. But if someone steals it, breaches a contract, hacks a system, bribes an employee, that's misappropriation, and the law absolutely can come after them for it. The Coca-Cola formula only stays a trade secret because Coca-Cola has spent over a century actively protecting it. The moment reasonable protection stops, so does the legal protection. There's no coming back from the grave on this one. Once it's out, permanently, for everyone, forever. So how do you actually protect something that has no registration, no filing, and no government certificate to point to? First, figure out what you actually have. Too many business owners have never sat down and made a list of things that give us an edge that we don't want a competitor to have. Do that first. Customer data, formula, source code, supplier pricing, internal processes. Write it down. Second, put the secrecy in writing with the people who touch any part of the information. Employees, contractors, vendors, potential partners you're already in talks with, they all need a signed confidentiality agreement before they see the sensitive stuff, not after. An NDA you send over after the conversation already happened protects nothing unless the other party agrees to make it retroactive. It has to come first, well before anything is leaked, because after that, it's too late, like Ray thinking of the Stay Puft Marshmallow Man. Third, limit who actually has access. If your entire team can open the folder with pricing formulas and vendor contracts, you don't have a trade secret, you have a very well-organized leak waiting to happen. Need to know isn't paranoia. It's an essential part of reasonable efforts. Fourth, mark things confidential. Actually lock down your systems. Use locked filing cabinets and locked rooms. And do exit interviews that specifically remind departing employees that they agreed not to share, in writing, with a signature, every single time. Have it notarized when they sign if you want to. Courts look at this stuff. If you can't produce a paper trail showing that you treated something as a secret, a judge has no real reason to treat it as a secret either. And when you suspect someone actually took something, a former employee, a departing partner, a vendor who went rogue, that's not a DIY moment. That's a call to your attorney the same week, because there are time-sensitive options like injunctions to stop someone from using or sharing what they took, and those windows close fast. So 4 things to remember from this episode. 1, trade secrets are the only type of IP where not doing any kind of formal filing is actually part of the point. 2, that doesn't mean doing nothing. You have to actively try hard to keep it a secret. 3, an NDA is necessary, but it's not sufficient on its own. You need those actual secrecy practices behind it. 4, you're probably protecting less than you think you are, and it's worth a real audit rather than an assumption. If listening to this made you mentally run through your customer list, your pricing sheet, and your least favorite ex-employee, that's normal. That's basically what this episode is for. If you want a second set of eyes on what you're sitting on and whether it's actually protected under the law, that's exactly the kind of conversation to have with an IP attorney before there's a problem, not after. If you want to talk with me, you can book a consultation at kingpatentlaw.com. If you're listening on Apple Podcasts, by the way, a quick rating or review genuinely helps other people find the show. Takes 30 seconds, and I'd really appreciate it. I'm Julie King. Avoid the legal horrors and keep rocking your IP. Thank you for listening. This information is for educational purposes only. It's not legal advice and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney. This episode contains attorney advertising material. From address and contact information are available at kingpatentlaw.com.